Grundy County Sheriff Ken Briley. Sheriff, the floor is yours.
Thank you, Senator. Appreciate it, and welcome everybody to this event. We're really concerned about this bill from a law enforcement standpoint. Jason mentioned several people that would be let out of jail as a result of this law, but I have to look at it from prior to jail at the street level. The citizens of Grundy County and across the state of Illinois, when they call 911, they expect the police to show up and resolve their problem. This bill is going to make it very difficult to resolve problems, and in some instances, it's going to make it impossible. Let's take trespassing, for example. Trespassing is a Class B misdemeanor, and under this law, Class B and Class C misdemeanors are no longer arrestable. And, there's been talk, I've heard different people talk, well, you just simply don't understand the law. We in law enforcement operate on words like shall and may and will. The statute says that law enforcement officers shall issue a citation in lieu of arrest on trespassing if you can identify the person, if they have no obvious mental health issues or no obvious medical conditions. So when somebody shows up at your house, they're swimming in your pool, they're swinging on your porch or swinging on the swing on your porch, or just sitting around your fire, and you ask them to leave and they don't leave. Most of the times people can handle those situations themselves, but there are often times that it gets out of hand, and the homeowner, the business owner gets frustrated and they call the police. They expect us to show up and resolve that issue. We're not going to be able to resolve that issue if we can identify the person. The law says we shall issue a citation in lieu of arrest. That means that we can't arrest them. I've heard people say, well, you can remove them or you can relocate them. In order to remove them, they have to be willing to be removed or relocated. If they're not willing to, then that means that we would have to do other measures, specifically maybe going hands-on. When you go hands-on, that takes it to a different level. So it's going to be very challenging. I'm concerned because, like I said, we deal with trespassing calls every day. Every law enforcement agency in Grundy County deals with trespassing issues every day. And people are going to become frustrated that the police arrive and they can't do anything. They can't resolve their problem. And my fear is that people are going to take matters into their own hands. When that happens, we're going to make law-abiding citizens into criminals, and that's troubling to me. The other thing that I'm really concerned with is the retention of officers and the hiring of officers. We've seen a mass exodus over the last couple of years. We typically, when we test at the sheriff's office, we usually have about 130 applicants. This last time we had 40. I've heard that all across the state, every police department. I was at the sheriff's conference this past summer. The sheriffs that I talked to down there said that they cannot get people, and deputies are leaving their office, and there's just not a pool of applicants. What are we going to do when there's no police officers to respond to these calls? So there's a lot of issues in this bill that are concerning, but public frustration, public safety is a huge concern of mine.
Yeah, and Sheriff, go ahead, Steve.
Thank you, Senator Resin. On the trespassing, the sheriff brought up several great examples of it. I think it is important to note that they can still be arrested if they pose an obvious threat to the community or the person at the home. But it doesn't stop somebody from swimming in someone else's pool who's not going to hurt anybody, just wants to use their property, or to camp out in their front lawn. That would not be an arrestable offense unless that person is an obvious danger to the public or to themselves. And to be an obvious danger, I mean, my goodness, what does that even entail? Because to me, it's a danger already if they're on your property, but that's not enough. They have to be an obvious danger. And who thinks that's a good idea for society when we've got real issues with dangerous people that maybe don't seem so dangerous at first, and then something horrible happens later on. So it's really troubling, the changes to that law.
Well, and to all of your points, what is really the sheriff's, the state's attorney, Many people, they filed lawsuits against the bill. They've talked at length in the media about their concerns. My local law enforcement are not viewed as politicians. It's not political. And what we hear from them is their concerns for being able to do their job, their concerns to make our community, allowed to keep our communities safe. That's what we're hearing across the state. That's why this needs to be taken seriously. So the next question I have for Jason and Ken, how much involvement did either of you or even your colleagues across the state have when the Safety Act was written? I know that you all are represented by the Sheriff's Association or the State's Attorneys Association. Did you guys have a seat at the table?
I'll take this first. As Steve talked about, we didn't have a seat at the table because it didn't go through the process that it usually would at the legislator level. In this particular case, I don't know of any state attorney that had any input on the bill until after the lawsuits were filed. And when the lawsuits were filed and the deficiencies in the process were pointed out for the first time, we had heard that state attorneys were having discussions with legislators. And with this particular situation, with 58 out of 102 state attorneys actually filing the lawsuit, is that there are state attorneys that were not part of the lawsuit that are currently negotiating changes in the law with legislators. Some of those counties are DuPage County and Champaign County. So the answer to the question was nobody asked for our input until a lawsuit was filed.
And in regards to the Sheriff's Association, I know that the executive director, Jim Kaichow, had discussions. I know that he expressed his concerns, but to me, from what I gather, it sounds like it fell on deaf ears.
And so, and then also Senator McClure, you're sitting in the committee, Crim Law, that the bill should go through. What were you hearing from all of the different groups that typically support or more importantly, oppose the bill? Did they feel that they had a seat at the table in the negotiation for this very large shift in policy?
No, and I was speaking to these groups at the time that this was happening in real time, and they were just sharing their frustrations with me. And we have actually extended our hands out as Republicans and said, I will be at the table to negotiate this bill if you'll let us. And it seemed like at some point that might have been able to be done, and it never happened. And even on the most recent bills that have tried to correct some of the problems with the legislation, again, I said, I'll be at the table. Let us be a part of this to try to make our state safer and to correct the real problems with this bill. That was rejected. So it's been pretty much, behind closed doors, without a lot of the people that should be having impact on the legislation are not able to influence it much at all. So we'll see if that changes, but that's kind of how it's been up to this point.
So let's just get into the next question. And I'd like your perspective from all three of you. What's the most concerning aspect of the Safety Act from your profession?
I'll take the lead on that. It's the fact that this is going to embolden criminals. It's the fact that citizens are going to become frustrated with the police. Police chiefs and sheriffs across the state are going to have a problem with hiring police officers. People are going to be out of jail before we get our reports done. It's going to be a revolving door. We're going to continue to make arrests where we can, put people in jail where we can, but this is really going to tie the hands of the judges, who are the ones that are best suited to make the determination based on a lot of standards: criminal history, mental health, flight risk, a host of other things. They're the ones that are best in the best position to make a determination whether someone should be detained. And this bill is going to tie the hands of judges.
So can someone go into a little bit more detail on how this bill will tie the hands of the judges?
The judges will lose a lot of their discretion. And so right now, really, a judge has a broad power to say, okay, you're a danger to the community at large. It's for the public good that you, at the moment, be detained in jail so you don't hurt anybody else. In several crimes, several instances, they will lose the ability to do that, even if the person is a danger to the public. And the way the law works is that it says that you can be detained if you are accused of committing one of the following list of crimes, or if you're a flight risk. What crimes are included and what crimes aren't included is very important. The crimes that are not included are what are called forcible felonies that are eligible for probation. So if it's a forcible felony eligible for probation, you cannot be detained unless you commit another bad act after the crime itself, whereby you are trying to flee the jurisdiction, trying to avoid prosecution. Maybe you've got a plane ticket to China. But really, when I was thinking about this, the only way that you could really detain a person in a case based on this bizarre definition of willful flight is if you're like O.J. Simpson in the white Ford Bronco with a passport, driving out of Los Angeles. That's about the only way you're going to be able to be detained based upon this definition. So you might ask, what are those forcible felonies in which you can only be detained if after you commit the offense, you then do another bad act where you're trying to flee the jurisdiction? And those are aggravated battery, robbery, aggravated robbery, burglary, arson, kidnapping, threatening a public official, intimidation. That would include witness intimidation. And Senator Rezin, one of the big issues I've got with that is that one of the most dangerous crimes there are in our neighborhoods across this state are shootings, and most of which go unsolved because people are too afraid to testify. How on earth can you have a situation where there's a police report, a witness is saying this person is intimidating me, trying to get me to not speak to police, and we can't keep that person in jail? After this allegation is out there and it's been shown in court that there is enough evidence to substantiate these charges, you can't keep a person in jail for witness intimidation, hate crimes, second-degree murder, aggravated assault, disorderly conduct where you've got like someone threatening a school. So those are crimes in which you can only be detained if you after you commit the crime, you decide to try to flee the country or the region to avoid being prosecuted. You have to try to conceal yourself, is what it says, I think, in the willful flight definition. And then there's a whole host of crimes that are class 4 felonies, which you're just not going to be able to be detained at all, whether you're a danger to the public or the community, or whether you're a flight risk or not. It doesn't matter. And those felonies not subject to detention at all include aggravated fleeing and eluding, which Jason brought up, mob action, communicating with jurors and witnesses, concealing or aiding a fugitive, obstructing justice. But another one that might hit close to home is aggravated cruelty to animals. So if you've got a pet, a dog that you love, we've had many dog family members in my household. I'm a big dog lover. But if someone goes and kills your pet, that's aggravated cruelty to animals. Guess what? You can't have that person arrested anymore. They can be booked, they'll have their mugshot taken, and then they're going to be released. So, the concern for me is there's a whole host of crimes in which dangerous people are not going to be able to be detained unless they're a willful flight, which is a ridiculous standard that's never going to be met in almost any case, or they can't be detained at all. And when you've got these people that can basically do whatever they want and they're not going to be put behind bars until after trial, and trials, by the way, in the state of Illinois can take years sometimes. I mean, talk about emboldening criminals. And by the way, the other bad thing about this legislation is that since it passed, we have seen a record number of sheriffs either not run for re-election or retire, a record number of law enforcement just leave the profession or move to a different state. We've got now issues in Chicago where people are calling 911 and there's no police to respond to them in a timely manner. So hours can go by with serious crimes and the investigation goes cold. And one case I saw recently where the people continuously kept committing crimes and no police could come. It's not because the Chicago police did not want to come. It's because they've lost so many officers to other professions or to retirement or to other states, that they couldn't respond to these crimes. So less accountability for criminals and less police on the streets are basically what this act is made happen in our state at a time when crime is out of control.
Thank you, Senator McClure. So, State's Attorney Jason Helen, what are your concerns regarding the Safety Act? I mean, we've heard about, Senator McClure said that you can only detain somebody if you can prove they're going to flee, which is a very, very high standard. And there's a whole list of non-detainable offenses that he went through that, despite committing these violations, that the felons cannot be held.
All right,
Jason,
I'm here. The one thing I wanted to talk about that nobody really talked about, one of the concerning aspects that I have that hasn't been addressed, is victims' rights. And in this particular bail reform law, is that we have to prove that an offender is a threat to a specific identifiable individual in order to detain them on a qualifying offense. And an example would be if an offender committed a DUI and killed somebody in a DUI crash on a Friday night, is that the State Office of Pretrial Services will evaluate them for pretrial release conditions on Saturday, and they could be immediately released. And under the state of Illinois law, we cannot detain an individual for an aggravated DUI that caused the death of another. And I can only imagine having a victim's family come to my office on a Monday morning and say, what do you mean that this particular individual is not in custody? Well, under that law, they're not eligible to be detained, and we cannot file a petition because it's not supported by the law. One of the
and why is that? Can you explain what in the
Yes.
law makes it so you cannot detain somebody, or somebody in a domestic abuse where they killed their spouse? So the spouse is killed. If you can go into the detail there, can you detain somebody in that circumstance or not?
In those situations, the law reads as follows: all persons charged with an offense shall be eligible for pretrial release before conviction. If you commit any offense, you can be eligible for release. After if there's a detention hearing, a judge could release somebody under the law for first-degree murder if he chose to do so. And one of the allegations in our lawsuit is that the Constitution provides that a monetary bond exists, and that if somebody's a danger to the community at large, an appropriate bond can be set. Well, in this statute, they stated that we have to identify a specific identifiable individual that they are a threat to detain them. And the problem is when the Constitution conflicts with the state law, the Constitution controls. So one of the allegations in the lawsuit is ultimately that law should be deemed invalid because that holds us to a higher standard than the Constitution requires. The example that you talked about, if I committed if an offender committed a first-degree murder on their wife and the wife is dead and they're no longer a threat to them, is that we can't prove that they are a threat to a specific identifiable individual because they already murdered the person. I've been told during the conversations with the legislators in trailer bills, and I won't believe it until I see it, is that they are going to remove that aspect out of this law and go back to giving the judge more discretion with taking out that specific identifiable individual and allowing them to detain offenders under more circumstances.
So essentially what we're asking for, what we're hoping will be negotiated, is the ability, giving the judges more discretion to detain based on, past history. If Sheriff Riley arrests somebody and they have a huge, rap sheet of all of these offenses that they have committed, then they could be viewed as a threat to public safety and they should be able to be detained. That's the amendment that is being worked on. But currently under the law, you cannot look at past history. Am I correct on that? If they're a threat to public?
You're correct on that, because with this particular law, it basically says you can only file a petition to detain if they commit a qualifying offense. And it is very limited on that. And the negotiations with the state attorneys that did ensue have been that they want to increase the detention net of where a judge has the authority to detain an individual because they're a danger to themselves, a danger to others, based on the nature of the offense, but based on their criminal history. So that's currently a subject of negotiation. What ultimately comes out of that, I don't know, but it's always great to give examples, and our state attorneys are given examples of why more people need to be detention eligible. I saw one of the questions was, now, is there another state that has laws that we should model ourselves based on? And some of the state attorneys have been talking about New Jersey and some of the things that have happened in New Jersey. I'm not so sure what happened with their laws with the bail reform, but that's definitely a discussion point, whether they're taking a look at New Jersey, California, New York, whatever the jurisdiction has been. Is that a common jurisdiction that keeps on popping up with the state attorneys have been, take a look at New Jersey as a model and not Illinois for the reform here.
Senator McClure, do you know a little bit about the difference between the bill that was passed in Illinois and, say, a state such as New Jersey, what they have passed?
Sure. So in New Jersey, when they decided to change the system, what they did was they implement all kinds of new technologies. For example, they have GPS electronic monitoring in the state of New Jersey and enough officers to monitor this electronic monitoring. So if a judge says, okay, we're going to put you on home detention, but you've got to wear an ankle bracelet, ankle monitor, that person goes home, and if they leave the house, they've got an officer that's looking at their movements and knows that they've left the house. They know exactly where they go, and they instantly respond to that. We don't have that in the state of Illinois. They didn't make any steps to do that. There's not enough officers in our state to monitor everybody that's on electronic monitoring, and we don't have GPS electronic monitoring. We don't have it in Sangamon County, and I'm not aware of any place in the state that does have it. Maybe some jurisdictions do. I'm not aware of them. Another thing they implemented in New Jersey was a text messaging system to remind people of their upcoming court dates. That's helpful. But they also make it so that if you're a danger to the public or community, whatever the crime is, you can still be detained. So lots of this has been around the discretion of judges that they lose. In New Jersey, judges get to keep discretion. And they do get to have a middle ground if a person is not showing up for court. A judge instead just saying, okay, you're just going to stay in jail no matter what. A judge can have a middle ground where they say, okay, now you're going to have to post some bond if you want to get out, so we can just have some assurance that you'll be back in court. The judges in Illinois lose that discretion. So I think it's key to remember in New Jersey, judges still have a lot of discretion to keep the community safe and to give people reasonable options to ensure that they're going to go to court. And people are monitored. People are monitored in a way that's not done in Illinois to try to keep the public safe. But even with all those safeguards, crime still went up among those that are charged with new offenses while pending trial. There's no state that's passed any major criminal justice reforms or bail reforms in which crime has stayed the same or gone down. It always goes up. And so I think what I would argue, and a lot of other people are arguing, is that with crime out of control, we have to make sure first and foremost that we're protecting the people of Illinois. So let's get those GPS electronic monitoring. Let's hire enough officers to be able to monitor these people if they get home detention. And let's make sure we've got enough officers on our streets to keep the public safe. Right now, this bill just simply strips law enforcement of important protections and strips judges of their discretion. And, look at a state like California too, Senator Resin, where the legislature and the governor enacted, they took away cash bail, and the people of the state of California, this is not a conservative state, this is a very liberal state, voted by referendum to void that law. So we are seeing the outcry among people because you know what? It doesn't matter if you're a Democrat or Republican or independent. you want to be safe in your state, and you want to make sure that your family is safe. Unfortunately, this bill does not have the proper safeguards that other states have put in place, like New Jersey. But like I said, even New Jersey saw an uptick in people that were released committing new crimes.
So before I go to Sheriff Briley, Senator McClure, can you talk a little bit about the 48 hours before? So somebody committed a crime, they put an ankle bracelet on, law enforcement cannot look for them for what, 48 hours? Can you explain that a little bit under the Safety Act or in the Safety Act?
Yes, this act goes out of its way to allow criminals to continue whatever criminal activity they are doing. It makes it a point. They're not concerned about victims. They're not concerned about public safety. They're only concerned about criminals who have, let's be honest. If people are accused of crimes in this state, they have to do so with evidence. It's not like they're just finding people and saying, oh, you committed aggravated battery, we're just going to arrest you. I mean, you've got to go before a judge and show that you've got probable cause to arrest somebody for this crime and probable cause to charge them with a felony. So there's evidence hearings that you have to go through before you even get to the point of an actual trial and everything else. So if someone is accused of something, there is evidence. And if there's not evidence, the judge has to say, okay, you can go home. So these people that are accused of crimes, some of which are going to be able to go home on electronic monitoring, are allowed to violate their electronic monitoring. In other words, the judge says you're on home detention, you're sitting at home, and the monitoring device shows that you're at home when it's checked. Well, now you can leave for up to 2 days. We don't know where you're going because, as I said, we don't have GPS electronic monitoring in this state. And all we can do is wait 2 days and then file documents in court to try to get you in trouble for doing that, and maybe try to get you back before the judge or try to rein you in as to whatever you're doing. But so in other words, for all we know, you could be contacting victims, you could be doing drug deals, you could do anything in 48 hours before police can do anything about it or the state's attorney can do anything about it. What on earth is the rationale for that? I mean, give me a break.
What is the rationale, Sheriff Briley?
I'm with the senator. I don't have any idea, other than I think it was intentional. I think it was truly intentional to protect criminals, and there's no care for the victims. I saw one of the questions in the chat about, as the sheriff, do I have the authority to exempt Grundy County from this law? And the answer to that question is no. But to expand a little bit further, think about the training for police officers on this bill alone. This bill is 764 pages. Jason mentioned that there was over 200 statutes that this bill touched or affected. The bill then had 2 or 3 trailer bills, and now we're talking about another piece of legislation maybe in the veto session. This bill goes into effect January 1st. At what point do we start training the police officers? Because they're hearing what's going on. They see what's on the news media. They're confronted in the public about these ridiculous changes. We can't tell them today to do this and expect them to know what to do tomorrow, with these bills constantly changing. At some point, we have to be able to train our police officers on what they can and can't do. We truly are bound by the legislators who set the laws. We're just there to enforce them, but we have to know what ground rules we're playing on.
Before I go to the next question, Sheriff Briley, and I know that we touched regarding many concerns with the bill, is there anything else that you would add? What's your most concerning aspect of the Safety Act?
Boy, that's a tough question. There's a lot of concerns. Safety. We're responsible to make sure that people are safe. And this bill is going to make it very difficult. Everything that the Senator McClure said, the things that Jason said, they're all legitimate concerns. And if the people don't feel safe, what are the people to do? And I don't want to see frustration with law enforcement. I don't want to see people taking the law into their own hands. So that's concerning to me.
So we've heard a lot about certain offenses that are not detainable or that will be extremely difficult, near impossible to be able to detain people pre-trial. State's Attorney Helen, can you talk about that and explain the concern there for these certain serious offenses? Without getting too deep in the weeds, if you can explain it and give examples for people like me that's listening on this Facebook Live.
Well, one of the things that we've been dealing with in Grundy County for the last 10 years is the heroin epidemic. And I think when you see how many people have lost family members or loved ones due to heroin use or some type of opiate use, that's a major problem. And one of the things that we're seeing in the local community lately has been the uptick on fentanyl overdoses, where an individual gets drugs off the street, they use it, and they die because it had a fentanyl-laced heroin, and that's a major problem. And the detention net simply needs to include more offenses. And one example that I gave that nobody could believe is that under HB 3653, if you're engaged in fentanyl trafficking on Interstate 80, and let's face it, Interstate 80 is a major drug corridor in the United States. And we pull somebody over who's got no connections to the community. They have enough fentanyl to kill everybody in Grundy County, is that we cannot detain them under that law. In order to prove willful flight, we'd have to prove they got a plane ticket to get out of here. In order to detain them on that particular offense, it's not even detention eligible by the definition of the statute. So that's just one good example of how somebody who's a danger to the community that possesses a drug with intent to distribute in large amounts on the interstate that have no connection to Grundy County simply cannot be detained.
So what would happen if they're arrested? They would go and then they would just be, put on an ankle monitoring and then expected to come back for their court date?
The process as it's laid out is that they would be evaluated for pretrial release conditions by the Administrative Office of Courts, pretrial services unit. Once they're evaluated for pretrial release conditions, the most common one's going to be electronic monitoring. They're going to be free to leave. And the problem that Steve had mentioned earlier is that in order to implement this law, is that the Illinois Supreme Court created a new agency, Office of Pretrial Services. And the Office of Pretrial Services a year ago had approximately 12 employees. Their goal was to have 150 employees by this year's end, and they're going to set up in 68 counties in the state of Illinois that do not have any form of pretrial release right now. The other 1/3 of the counties have pretrial release conditions where the judge orders the offender to meet with probation prior to their court dates, start getting evaluated for substance abuse and mental health issues, and start receiving treatment prior to a disposition on the case. In Grundy County, we're one of 68 counties that have no form of pretrial release. So that's where the Office of Pretrial Release is going to start in the 2/3 of the counties that don't currently have any form of pretrial release. We are going to have one, maybe two individuals that are assigned to Grundy County to monitor, well, I shouldn't say monitor the individuals. They're supposed to monitor them. But what we've been told by the state agency is that they're going to evaluate the individual, make a recommendation to the judge about what the pretrial release conditions should be. The judge is going to accept or reject the recommendation, order the pretrial release conditions, and we've been told that once they're evaluated, the judge makes a decision that they don't have the resources to monitor the people on pretrial release. And I was told by the individual from that office is that it should be the state attorney's job to monitor the individuals, whether they're violating the pretrial release conditions. And I said, that's not our statutory duty. Our duty is to prosecute, not monitor pretrial individuals that are released. So we've already been told right now that it's not practical to enforce the law as written because it's not adequately funded by the personnel in the Office of Pretrial Release. So that's got to get addressed.
Sheriff Briley, I know that State's Attorney Holland went into certain offenses that are not detainable. What's your opinion? What's your feeling regarding the non-detainable offenses?
Well, he brought up a good point. All drug offenses are going to be non-detainable. I can tell you that Jason and I, over the last several years, have done multiple heroin forums to try to educate the public, let them know what resources are available. I can't tell you how many parents have come up to me and said, my daughter's in jail, but at least I know I can sleep tonight. I know that she's safe. I know where she is. I know that she's going to wake up in the morning. That's sad when a parent has to wish that her daughter be in jail just to know that she's going to be safe and be alive the next day. This is a situation where drug offenses are not going to be arrestable. And that's oftentimes where we have the ability to get someone, have some time with them, get them clean, show them other opportunities, and then release them back into the community, hopefully with a chance to succeed. We're not going to be able to hold people for this anymore. And without that, you're not even going to have time to get somebody to get the drugs out of their system. Again, like I said, they're going to be back out on the streets before we get the reports done.
And I think what we've been hearing again from all of our sheriffs and state's attorneys is to try to educate the public on what they're going to see in less than 60 days when this bill takes effect. Because the people that will be asked, why is this person back out, or why didn't you hold this particular, offender, and because you can't. So you've been trying to educate people, and I think that I just did a lot of town halls throughout my district, and bar none, that was the number 1 issue, people concerned with this Safety Act. Senator McClure, what changes would you see, or would you, currently there's people negotiating an amendment to the bill. I mean, what kind of changes would you see that would be fair and equitable, yet not put public safety at risk?
I think the first change that I would want would be to give judges discretion, no matter what the crime, if a person is a danger to the community at large. That's a big deal because, this tying a judge's hands when you're dealing with offenses that are serious, and some could even say nonviolent, for example. Like one offense is burglary. And some people may say, well, if somebody's breaking into a business or some abandoned building or whatever, they're charged with burglary. Who cares if a judge can't keep them because it's not a violent offense? Well, my response to that would be just recently, I think this was last year, but the bail reform laws in Cook County, which have really rained havoc on the people of particularly Chicago, there was a guy charged with burglary, and he was released. He ended up burning down a house with his girlfriend and her child still inside of it, killing both of them, murdering both of them. And so a judge really needs to have the ability to look at a full picture here and make the determination, because, what was Al Capone charged with, for example? He wasn't charged with the most serious crimes he actually did. It was like tax evasion, right? Judges and state's attorneys have to have the ability to protect the public, and our sheriffs do, our law enforcement do. To take it out of their discretion is going to, people are going to be killed because of this law being passed. There is no question about that. And so, number 1, you got to put things back in the discretion of judges. Number 2, which I've talked about already tonight, is GPS electronic monitoring with enough law enforcement to actually monitor them and to react immediately if they violate those monitoring devices. I'd also say that in cases where you've got a massive amount of money being taken, particularly from seniors, like financial exploitation of the elderly. And when I was a prosecutor, I did those cases. You have to be able to ask for bail in those cases, because that's the only way that you ever get money back, quite frankly. It's really easy for criminals to get convicted of crimes, be forced to pay restitution, and never pay. And we've got people all the time that are put on probation. It's a condition of their probation to pay back whatever the victim is owed, and they never do it. And it's converted to a civil judgment. Their probation is terminated, and the victim never sees a dime. The only way we get money back is if they pay bond for that. So I think for financial crimes, you've got to have bond. And the judges have to have the discretion, and we have to have more tools for law enforcement in our communities to keep people safe, like GPS electronic monitoring.
Thank you. Sheriff Briley, what say you? What would you like to see changed in the Safety Act?
We gotta stop coddling criminals. We've got to allow officers to be able to do their job. You know, Jason brought up a point about criminals running from us. In the last 18 months, the sheriff's office, just in Grundy County, we've deployed stop sticks 19 times, successful deployments 19 times for people that were running from law enforcement in the last year and a half. That's a crazy, absurd number. And this law emboldens criminals. And like Senator McClure said, this law is dangerous and people are going to die if things don't change.
And then lastly, Jason, what are the changes that you would like to see in the Safety Act?
One of the realistic changes that we expect during the veto session is clarity on whether the law has a retroactive or prospective approach, because there's been a lot of conversations about, well, criminals aren't going to get let out on January 1st. And the state attorneys have been having conversations about what we're going to do if cash bond is abolished on January 1st and a person is sitting in jail right now on an offense such as possession of a stolen motor vehicle, and that's not a detainable offense after January 1st. Are we still able to detain them on a cash bond on January 1st for that offense, or is the cash bond abolished and they're released? And an example would also be if somebody did not show up for court and a $50,000 10% bond was issued today, is that warrant quashed on January 1st? And that means the person just doesn't have to show up and law enforcement doesn't have the authority to bring them to the jail. So one of the major confusion points that seems to be an issue that can be easily clarified by the legislature is just to say, does it apply retroactively or prospectively? Because when we're having conversations and counties, large counties, say they're going to leave it up to their individual judges, and one judge might rule one way and another judge in the same county might rule another way, that violates equal protection of law. So that is a really realistic point that I think can get addressed.
Thank you. We have time for, let's see, we have a couple questions in the chat room. Again, I want to be conscious of the time and we're trying to wrap up around 7:30. There's a question from John. Feel free to answer it. If Class B and C misdemeanors are ticket issue only January 1st, can law enforcement, I just lost my, can law enforcement use force to stop the continued violation? Example would be trespassing to real property, window peeping, etc. Does anyone want to take that?
My answer to that question would be no. The statute clearly says law enforcement shall issue a citation in lieu of arrest, except for certain circumstances. If we can't identify them, we can arrest them, take them to the jail, book them through the fingerprint process and be able to identify them. Or if they're an obvious mental health risk or a medical condition, other than that, they are not arrestable. So we are not going to be able to use force.
We've had a lot of conversations about this, and of course there's a divided opinion about an interpretation issue, and you're talking about the citation in lieu of custodial arrest. And one police agency stated, well, just take them to the squad car, put them in the car, drive them to some other location and release them. And I basically told the sheriff that that would be a federal lawsuit under section 1983, that taking somebody into custody is refraining their ability to move on their own. And you don't have to put somebody actually in handcuffs to consider that a custodial arrest. Taking somebody against their will, putting them in the squad car and dropping them off someplace else, that's not going to be the solution. And that's a really big problem.
Thank you. We have one more question from William. Is there a point where repeat offenders are outside the protection and considered a risk to society?
Well, as far as that, again, the criminal history is not going to matter. It's going to be what the current offense is. And when you take a look at the current offense that they're charged with, it has to be a qualifying offense for the state attorney's office to file a verified petition to detain that individual. So the criminal history does not matter. The previous failures to appear in court does not matter. And that's what's going to be very frustrating for prosecutors, is that people are just not going to be able to believe that offenders are committing crimes over and over again, and there's nothing that we can do to detain them prior to a trial.
Thank you. Again, I'd like to thank my panel for taking time out of their busy days. State's Attorney Jason Helen, thank you for being here. Sheriff Ken Briley, thank you for coming out of the deer stand to spend some time with us. And Senator Steve McClure, my colleague, thank you for being on this panel. Steve has been a good voice for people down in Springfield to explain this bill and the issues and the problems with the bill. I mean, obviously, we are hearing from our constituents, not only in our districts, but throughout the entire state, with their concerns about the bill. The fact that you have law enforcement, the fact that you have state's attorneys who are typically viewed as apolitical positions, concerned about the implementation of the bill and how it ties their hands, is why we're having this discussion across the state. It is our hope. There is a working group that's meeting, hopefully, to allow some of the changes that you've heard tonight that were suggested. As you could tell, we're just not complaining about the bill. We have very legitimate complaints, but we're also offering up suggestions how to make the bill better. And those good suggestions are coming from your Sheriff's Association. They're coming from your State's Attorneys Association. And those are the bills that we hope to see when we're in veto session coming up or lame duck. Now, the problem is there's a lot of pressure because of the election coming up to say that something's being done. It's my hope that after the election, when we actually see the bills, that are legitimate, that they take into effect legitimate concerns by the sheriffs and the state's attorneys and address their issue and are passed in the amendment coming up. So again, thank you all for participating tonight.
Thanks for watching, and if you haven't already, please consider subscribing to our channel. And while you're at it, please leave us a comment. Thank you for watching.